Scarlett Johansson was in the news after an AI company used a sound-alike voice despite her not giving permission. Got about 10,000 comments. Is that about accurate?
We did, and we've read every single one of them. Certainly arrived at the conclusion that if it's purely generated by AI and there's no human involvement, there cannot be copyright protection. One of the things that I've been most excited about with the new ECS registration system is that it will be much easier for the average person to use without having any expertise. We are working on, the next step will be to develop a way to extract metadata from the records. We set up a new copyright small claims court. It's functioning incredibly well and getting close to 1,000 claims having been filed, so it's operating very smoothly and very effectively. We are right now in the process of finalizing a rule to allow group registration of news websites in a way that hasn't been possible before.
Registered Perlmutter, I'd like to begin my conversation with you about the AI initiative that you mentioned in your testimony. It's critical the office addresses the copyright challenges that result from AI-generated content head-on. It's impacting every corner of the creative community in the United States. And as we saw just last month, Scarlett Johansson was in the news after an AI company used a sound-alike voice despite her not giving permission for her voice to be used in that manner. Now, we've heard concerns from songwriters, from artists, photographers that are struggling with similar issues, and the stakeholders are eagerly awaiting guidance from your office. It's correct that the AI initiative has been in the works for now over a full calendar year, correct?
The issue has been around for about a year and a half. We launched our study, our AI initiative studying the issues in March and followed up with a notice requesting public comment at the end of August.
In March of last year,
yes.
Right? So a little over a year ago, you got comments in August, and you got about 10,000 comments. Is that about accurate?
We did, and we've read every single one of them.
And you've bucketed them into key categories: literary works, visual works, etc. I want to dive in kind of then on where you're at in this process, because a lot of people are waiting on this. Do you have an expected date for your review?
Yes, so we are issuing the report in sections, frankly, because there are so many issues. It would take too long to try to do one entire volume covering everything at once. So the first section will deal with the issue of digital replicas, the issue that Mr. Morelli has raised in his opening statement. And that section is close to being finalized, and we expect to issue it in the coming weeks. The second section of the report will talk about the issue of copyrightability of the output created using generative AI. And that study we expect to issue by the end of the summer. And then we will turn to the infringement-related questions, including whether the ingestion of copyrighted works for purposes of training the AI constitutes fair use, in what circumstances it might constitute fair use, and also considerations related to licensing and the allocation of potential liability. So those last sections of the report we expect to be out in the fall.
Without asking you to sort of preview what the recommendations are, is that, as you said, it's going to come out in a series of reports. Can you at least give me a sense of what sort of the analysis you did and sort of the process that you used to take new technology and things that would not have been even possible a decade ago, and sort of just give me your thought process on how you place that against the standards that we've used in the past. How do you what's been your charge to staff as you sort of work through this and sort of the principles that you've used?
We've basically been proceeding on two tracks at the same time, because one of the office's functions is to do policy analyses and assist Congress in analyzing copyright issues, and the other piece of our role is to administer the Copyright Act, which includes, of course, registering claims to copyright. So we have, throughout the last few years, been looking at claims in works that incorporate in some way AI-generated material. So that's been an ongoing process of having to draw lines and decide when there is sufficient human authorship in a particular work to support a claim to copyright. because in our view, and we've been upheld by the courts on this, human authorship is required for copyright protection.
And so you've sort of, I think, is it fair to say that from your perspective, that the notion of generative AI, where you can't trace an author, a human author, that is not copyrightable? You've kind of already arrived at that conclusion, no?
Well, we have certainly arrived at the conclusion that if it's purely generated by AI and there's no human involvement, there cannot be copyright protection. And the district court for the District of Columbia has upheld that decision. It's now on appeal to the DC Circuit.
Can you elaborate on the office's partnership with the Library of Congress and the Office of Chief Information Officer in this effort?
I'd be happy to. Before I arrived at the library had centralized IT work within the library for all of the service units, including the Copyright Office. So the way the relationship works is that the Copyright Office experts develop the business goals and priorities and needs, and then work very closely with OCIO to help them understand what we need and when and how, and then they essentially enable us to do it by developing the technology. We work extremely closely together. So I would say at all levels in both offices, we are in contact every day. So I meet regularly with the Chief Information Officer, Judith Conklin, and our teams meet regularly and work together, both formally and informally, constantly.
Okay. So do you feel like you're getting the support you need from the library and the CIO in order to advance these technology
Absolutely. We're working as a team, and we have completely shared vision of where this is going and how to work out the timing and make it happen.
Great. Can you tell me about the elements of the new IT system that will directly benefit an individual copyright holder who's trying to register a new work?
There will be a number of ways in which it will be beneficial to copyright holders. And of course, it's still in development, and we will be able to show a limited pilot by the end of the year of the standard application. So people will have a chance to see it and give us feedback, and that feedback will in turn go into further development. But one of the things that I've been most excited about with the new ECS registration system is that it will be much easier for the average person to use without having any expertise.
Okay.
So there will be a lot of help given in terms of understanding terms, knowing what categories to use, knowing what forms to use. I think that will be a tremendous benefit. There will also be ways in which it will be much easier to upload deposits. It will be faster, it will be easier to upload large deposits or multiple works at a time, and I think people will find that to be a great benefit.
Beyond digitalization, what steps is the office taking to enhance searchability and usability of these historic records for researchers and the public?
Well, thank you for that question. I am very excited about this project, and we, in addition to making those historical public records available online, and we've done about half of them so far, we are working on, the next step will be to develop a way to extract metadata from the records. Yeah. Right now, the great improvement is that people don't have to come physically to the Copyright Office to look at those records. They can see them online in digital form. The next step is to enable them to do the research without having to go through laboriously looking at each page. And we're working right now with LC Labs to test an experiment with some AI programs to see how we can engage in exactly that project of extraction of metadata. Gotcha. So I think there's a lot of exciting potential there, and
it's very critical that we figure out how to make it really searchable and usable. So I'm glad to know that you've undertaken that.
Understand the historical records, but when Ms. Sewell starts talking about books, some of those books are currently under copyright. And if you digitize them and you don't have a license, what's the underlying legal authority for that?
Well, we're not digitizing books under copyright. We're digitizing our records.
Just your records. So
yes.
if you're doing submissions or if you're putting your work in, that's not going to be digitized.
We don't take material that's not digitized and digitize it.
So you're not making copies digitally of material that could be copyrighted. or is
People
copyrighted?
can submit digital copies of their works
Yes.
as deposits, but we don't take the analog copies and digitize them.
Okay, and that's not a part of your plan that's coming out?
No.
What else is exciting going on over there that you haven't had a chance to tell us about yet?
Oh, wow. There is so much going on. It's been quite something. One thing that we're very proud of, we set up a new copyright small claims court 2 years ago pursuant to the CASE Act
Yeah.
that Congress
I think you
passed in
mentioned that earlier,
2018.
yes.
And it's functioning incredibly well and getting close to 1,000 claims having been filed. So it's operating very smoothly and very effectively.
But again, just so that I'm clear, you're not taking any documents that are filed as a part of the registration process and digitizing the document, the book, or the work for copyright purposes, just the registration forms.
Just the forms, the information that people have given us in connection with registration, but not the works themselves.
All right. I yield back.
Are you getting any feedback from these local news organizations and outlets during the listening sessions that you've done, in the public inquiry that's happening on AI, and on these copyright issues more broadly?
Yes, I would start by saying we actually did a report now probably close to 2 years ago about press publishers' rights in general, where we recognize the challenge for local news outlets and exactly the trend that you mentioned, and we expressed concern about that as well. We have gotten input from certainly from the news media and news media organizations. I would have to go back and check to see if any individual local news outlets filed separately, but definitely that area was well represented in the comments we received.
And is there an intentional effort to engage with news organizations during the decision-making process regarding copyright registration for AI-generated content?
Well, we certainly have an open door, and we certainly talk to the News Media Association, among others, on a regular basis about their interests and concerns. I don't know if that answers your question.
Yeah, I guess I'm more interested in whether there's been any sort of assertive, I believe you when you say your door is open. I wonder if there's just any direct effort to outreach to this industry because it is so potentially impacted by this.
Well, we've certainly reached out to them on specific issues, where we've had, for example, a notice of inquiry or a notice of potential proposed rulemaking. We are right now in the process of finalizing a rule to allow group registration of news websites in a way that hasn't been possible before.
This year, there have been many statements that have been made by the office that have caused concern regarding the efforts to modernize the office's registry system. During a meeting in February, the office announced a notice would be published the following month in the Federal Register to reauthorize the Copyright Public Modernization Committee and requested applications from interested parties. The notice was actually not published until March, and then it was only published after committee members sent a letter requesting an update. It is my understanding that many of the committee members would like to meet more frequently. Can you talk about why the office does not convene this critical committee more frequently than it does currently?
Well, the committee was set up through a regulation which specified that it would meet publicly twice a year. And frankly, I thought at some point we should talk more often, and so we started having informal briefings in between the public meetings. The committee was set up for a 3-year term, and it came to an end at the end of last year. And we had a final meeting where we had a conversation with the members about what their experience had been and what they would like to see going forward, talked about increasing the pace of meetings, and I think at least continuing to have informal briefings in between the public meetings is a good idea. Someone had said at the last meeting, had predicted that we would publish the notice to reauthorize in mid-March. Just due to the press of business, it ended up happening at the beginning of May, so it was about a 6-week delay. But none of that changed what the timing would have been to get the new committee up and running. The deadline for applying to be on the committee expired last week, and so we're looking at the applications, and we will hold the first meeting of the new committee this fall.
Can you provide a brief overview of key themes and issues that have emerged from the Copyright Office listening session on AI and copyright to date, including any discussions on how the office is partnering with international counterparts?
Well, let me start with that last part of the question. So we are in regular communication with international counterparts. I mean, it is just absolutely clear that AI technologies are being developed all around the world by people from different countries that they draw on and train on content from around the world. So we always have to be aware of the global context. So I have been in frequent conversation with counterparts and policymakers from countries around the world that are also examining these issues. And my belief is that the more we all share our ideas and our experiences, the more likely it is that we will get at least compatible approaches emerging around the world, which will avoid impeding cross-border communication and trade.
Can you provide an update on the progress made in the modernization aspects of ECS and relate directly to the copyright registration system? It's all your, the floor is yours.
Yes, I will say it's almost a decade since we started talking about modernization. The actual development work started in 2020, so now about 4 years ago. We have made a lot of progress. I spoke in my opening statement about progress in recordation and also the development of the copyright public record system. But you're asking specifically about registration. So on that, I would say it has been an area where we have just recently, well, over the last year, put a lot of our resources, in particular on expediting work on the registration component of ECS. So working very closely with the library's OCIO, we are making it now a top priority and moving around some of our resources so that we can speed up progress. And so that will include the launch of a limited pilot by the end of this calendar year.
I'd like to go back to the subject of artificial intelligence, particularly as it relates to deepfakes, misinformation. These are things that I know as members of Congress, we all continue to hear great concerns back from at home as well as here in DC. And I'm interested in your office's, I believe you've either have issued or will be issuing a report on digital replicas. And I'm interested in your perspective on whether copyright law is potentially the right vehicle to address these challenges.
You are correct. We are going to be issuing a report very shortly in the coming weeks on the digital replica issue. There are ways in which copyright law can relate to some of these challenges, but it doesn't directly protect someone's identity against its replication. So what we have right now in the United States is a whole array of different laws that could potentially apply in different circumstances. So and a lot of them are state laws, rights of publicity and privacy, unfair competition, and then also the Lanham Act at federal level. So in our report, we're going to be looking at in what ways do all of these laws, including aspects of copyright law, apply to what is happening out there in the world with these new technologies, and what are the shortcomings or gaps, and should there be a federal law that can possibly fill in those shortcomings and gaps.
If there's no further business, I thank the members for their participation. Without objection, the committee stands adjourned.